I could see that some senior good police officers had a note that said these emails are invalid by virtue of how we secured them. But they didn't drop the charges because politically this case was motivated to achieve a political aim. And I'll explain it to you. So for 4 months, the investigation is ongoing. Steve gets a tip, General Whelan gets a tip that he's under investigation. He calls the chief of defense staff and he says, "Sir, I'm under investigation. I want to protect these forces that I love and I've served my whole life. I'll resign for you." And the chief of defense staff says to him, "No, there's nothing there." Now, one of two things are true. The chief of defense staff was aware of the investigation and believed nothing was there. Or two, they were a few weeks away from an election between Trudeau and O'Toole. And what we would have heard at the trial, if we would have been able to go forward, and I'll explain to you what happened at the trial, is that these type of major political events affect how the Canadian Forces is led, because the government is unbelievably concerned with scandal. And if another scandal had emerged, it could have affected Trudeau's election. Who knows? But what we know is the CDS said, no big deal, stay in your job. And then all of a sudden on October 15, 2021, a Globe and Mail story breaks that puts Lieutenant General Whelan in the same category as a bunch of other officers who have been charged with sexual offenses. And it's leaked, but the investigation is still ongoing. The military police haven't investigated all of the witnesses yet. The complainant deliberately withheld from the police one of the most important witnesses who would have given visibility on what happened. She actually lied to them about the existence of this person, which nobody picked up on and nobody seemed to care about later. But if you're raising an allegation and you hide a very important witness, you're almost obstructing the investigation. And I believe that this woman could be charged for doing this because the Canadian Forces spent millions of dollars on this court-martial. And if she would have revealed this witness, I believe the police may never have even got close to the charges in the end. That being said, the complainant was clear that she wanted my client removed from command. And she said it's taking too long. And I have the notes with her and the police officer. And then what ends up happening is she calls the police and says, "Why hasn't he been fired yet?" And she's very angry and she's threatening the police. And she goes, "I talked to the media and the class action lawyers and they say nothing happens unless this gets in the media." And the officer says, "Well, we can't tell you what to do, but you can compromise an investigation if something gets to the media before we've been able to do our job." 2 hours later, the story breaks in the Globe and Mail. And that's something you're not seeing from the Globe and Mail reporter. She's not talking about her involvement or how she was used by a complainant who was using the media to get what she wanted because she wanted him removed from command because he was going to oversee her release. That anonymous leak that the Globe and Mail said that they didn't have authorization is a crucial part to this case because complainants can speak to the press if they want, but to do an anonymous leak when the investigation is ongoing, that brings some serious credibility issues to the table. And the fact that she said she was speaking to the media and threatened the police, and then it comes out, and all of a sudden, as soon as that media story hits, he's relieved from command. His life is destroyed. Protesters start bothering his family at home who have no idea what the heck is going on. And he spends the next 2 years in absolute grief and stress and huge legal fees, trying to clear his name from somebody who has kept select emails, not included the ones that she was writing that were manipulative and trying to get this general to do what she wanted. And all of a sudden we're sitting in a court-martial in Gatineau, Quebec, right beside Ottawa, and this man is going to fight for his life. And I know that they thought he was going to plead guilty. I know that they thought he was going to plead guilty. They hit him with 2 soft charges, and they thought he'll just plead guilty like everyone else, but Lieutenant General Steve Whelan is a freaking warrior, right? And when he asked me to help him, I would die before, I'd be carried out on my shield before I let that man suffer a wrongful conviction because they thought they could bully him into it. So let me give you the context. There's 2 charges. First charge is engage in improper communications and make advances towards a subordinate. Second charge, these are just conduct charges, the lowest charges in the Canadian Forces. Second one is negatively affected an annual report for improper purposes. Now, everybody who you talked to in the military said, what the heck are we doing court-martialing the most senior officer in Canadian history over 2 conduct charges that can be dealt with administratively? And that's because the Canadian Armed Forces leadership, 2 people above him, CDS and VCDS, are politically influenced by the Prime Minister's office. And they were terrified that if they withdrew it, this person would go to the media again and they'd be broad brushed as being insensitive to complainants. So I'm like, all right, let's go to trial. Let's let the justice system shed some sunlight on the accusations, because everybody thought he was going to roll over. And in the process, I was able to get further disclosure that they were holding back from us, which changed the nature of the case. It actually revealed, I think she mistakenly included some more emails that were sent to us. We end up showing up for first day of the court-martial. And unexpectedly, the prosecutor withdraws one charge, the improper communication. So the improper communications are these emails that she provided from a one-sided perspective. My client didn't keep things from 10 years ago, but had like a memory of all of these things. And you could see in the emails that they didn't follow the timeline. And there was very clear evidence that they were selected and cherry-picked. So the prosecutor withdraws the charge of improper communication. So that's no longer before the court. On the day the court-martial starts, set for 2 weeks. I don't understand what happened or what changed there. And originally they wanted, on the second charge, change the PER for improper purpose. Every part of the investigation was designed along the lines that the charge was based on she said that he made advances to her. She refuted them while they were deployed in theater. And so he gave her a worse PR than she deserved. Right up until the day the court-martial started, that was what they were aiming towards. So on the day the court-martial starts, they remove the first charge, the improper communications, and then the prosecution says, hey, by the way, on the first charge, it's not that she got a bad PR because she rejected his advances, which was not true. It's that he's guilty because he gave her a better PR than she deserved because she threatened to release the emails to his bosses, the emails from before the tour. So essentially, the prosecution said that she was extorting the chain of command to get an evaluation she didn't deserve, which I don't think they really thought that through, because they essentially made their complainant look like they were an extortionist, which blew my mind away until I finally figured out what happened. So then we proceed with this second charge. I'm shaking my head on the first day. They call one of their two witnesses, and the colonel is like, the colonel who's called, he says, oh yeah, I wrote her a PR that I thought was deserved. He calls her unstable and discusses how there was threats to go above the head of my client and report to his superiors and the ambassador on a very high-profile mission these emails, which it was close to the end of the tour and could have compromised Canadian reputation in theater and the success of the mission. In the end, my client and this colonel decided that the colonel would give her the PR he thought he deserved, because General Whelan was, at the time, Colonel Whelan was so high up and so busy, like it's not something he should be dealing with. And this is what this colonel said. So he said, yeah, I gave her the PR that I think that she deserved when I thought about it in the end. And he said clearly that Colonel Whelan was focused on the mission. He was an outstanding leader, and he had misunderstood what happened at the time because the complainant hadn't been honest with him about what she was telling him about Colonel Whelan. Then all of a sudden, the prosecution wants to enter into the record the emails that were the substance of the first charge they withdrew. And it's fascinating, if you can follow me, and I hope I'm explaining it well. When you withdraw the first charge and the substance are these communications, that's no longer before the court, but they kept the second charge, which was kind of the less serious one in a way. But they said, we're going to try to convict you on the second charge, but we want to get the emails into the record and in the press. And it was odd to me, because I'm like, you don't need to get the actual emails into the record when we admit that the emails would be embarrassing personally because they were flirtatious. And he was married. He loves his wife, and his wife is still with him. But he made some errors in judgment because he was being charmed and manipulated by this complainant. And it could hurt his career. He admitted that if those were sent out into the media or to his bosses without him being able to explain, it could hurt him. But they wanted to actually enter the emails in that she had cherry-picked and that the Crown had cherry-picked, the worst ones. They wanted to put it in the record. And I'm saying this hypothetically because I'm not sure I can say it. But imagine a prosecutor says to you, hey, if you don't want this embarrassing stuff to go into the media, just plead guilty to this last charge. And I'm telling you, it almost worked, because the fear of it going into the media for a man who has been through all of that was like, okay, I can just plead to this charge and then it won't get in there. And the government then looks like, hey, we got out of this embarrassing situation and we still look like we won, because our defense was calling the chief of defense staff to account for his actions and the political interference. I had an expert that was going to rip apart the military police for one of the worst investigations I've ever seen. And I was going to absolutely destroy the complainant and maybe get her perjured on the stand for all of the lies that she had told. But I'm telling you, there was a second where it was like the fear of getting those emails almost resulted in surrender, except we decided to fight getting those emails in on a 2-day evidence hearing where I said they're not relevant, they're not probative, and if they're probative at all, they're way too prejudicial to my client in light of how much bullshit had gone on so far. Reports in the media that mischaracterized him. The chief of defense staff actually wrote my client a letter saying, I'm relieving you of command because this was in the media. You know, the guy hadn't done anything else wrong, but once it gets in the media, he's now being relieved of command. That's not morally courageous. Anyhow, so we fight it, and I'm like asking myself, why is the prosecutor fighting this so much? Like, why does it, we actually said we're going to put a publication ban on the contents of the emails until they're deemed relevant or not, and he fought it. And then he fought to get the emails in when the judge was essentially saying, look, to make your charge, you don't need these emails. The judge said it to him. He goes, you don't need these to be successful on the second count. But they kept fighting it. And the whole time during the trial, I'm thinking, what am I missing? And sometimes you focus on the wrong things and you just give people the benefit of the doubt. And I should have sucked back and breathed, because there was something going on with this prosecutor. Nothing in his strategy made sense. I didn't feel like he was fighting his own case. Like, he didn't seem to come prepared. The only thing he seemed prepared for was these emails. So when they lose the email battle, the complainant had testified on a Thursday, and they were trying to get the emails in. And on Thursday morning, prosecutors told the emails aren't going in, call the witness. The prosecutor calls the complainant, their only other witness on this giant case. And I don't think she even knew what the prosecution was trying to prove at this time. I think she thought it was going the original direction, and her answers were kind of all over the map and not particularly enthusiastic. And she's even asked, well, was there any talk about releasing emails? And there's this long pause that was painful. And she goes, I don't remember. So imagine if somebody said, give me a PER or I'll release these emails to a general. And then in trial on the stand, the prosecution asks you, do you remember talking about releasing these emails? And long pause. And she goes, I don't remember. It's completely not plausible. That's almost the last question that happened on Thursday. So we adjourn on Thursday, can't do court on Friday. And Monday morning, I'm set to cross-examine her, and I've never prepared more for a witness in my life. Like, I had every T crossed and I dotted, everything referenced. I was going to lead this witness right down the path to perjury, or who knows what else, because there was so much data to work with. So Thursday evening goes by, Friday goes by, Saturday goes by, Sunday goes by. Monday morning, the complainant is at the court-martial in her uniform, ready to get cross-examined by me. I have my whole setup in court ready. I'm pacing back and forth like a caged animal who's had adrenaline. I've worked every waking moment I can. And then all of a sudden, just before we start, prosecutor says, can I speak to you? Brings me and says, I'm withdrawing the last charge. He's like, I'm sorry. I'm like, what? Why are you telling me now after 4 days? He goes, I'm sorry. And it just so happens that my assistant saw him in the car right up until that moment he came in on the phone. So you have to ask yourself, would you not tell the complainant if you decided that you're going to withdraw the charge over the weekend? Would you not call the lawyer and give him the courtesy of a call and say, hey, don't prep all weekend because I've looked at what happened on Thursday and we're not going to proceed? No, he got the call at 9:20 in the morning. We started at 9:30. And the question everybody's got to ask from is, who called him? Who called the prosecutor in charge of the case just before the case was to start? Because if I finished that cross-examination, it would have revealed a whole bunch of damaging stuff to the government and the police. And after that, the Crown would lose the ability to stop the court going, because then my case would start. And General Whelan was going to take the stand and expose all of the nonsense that goes on behind the scenes at NDHQ. And my expert was going to testify and show how bad the military justice system responded. And I think they responded so poorly because there was pressure for them to find a charge, because the police, many of the police officers removed themselves because they didn't want to lay a charge. And the prosecutor in this case was the third prosecutors. Two others had removed themselves. And then I was going to finish off with the chief of defense staff and the vice chief of defense staff, and I was prepared for those guys. Ask yourself, was this prosecutorial independence when at 9:29 in the morning, before I'm about to cross-examine the complainant who's ready to testify, who hasn't been told she's not needed? Is that prosecutorial independence? Or did somebody from Ottawa call? And I can tell you, if it was the director of military prosecutions, who has a direct line to the provost marshal, who's the head of police, who has a direct line to the vice chief of defense staff, who was going to be my witness, who has a direct line to the deputy minister of defense, who reports to the prime minister's office, that didn't want this to go out, I can tell you, I'm going to find out and prove that that's where that call came from. But if I was a director of military prosecutions, I wouldn't be calling a junior prosecutor to do my dirty work. I would drive down and withdraw it myself, because that's what a leader does. Instead, we're pretending that this was just some factual change of circumstance from Thursday. This was a deliberate political move on behalf of the Canadian Armed Forces and the Prime Minister's office to prevent this from getting out. That's not the Prime Minister's office. So that's a very quick summary of what happened. Go on to the Globe and Mail and look at, they just did a podcast called Decibel. You can hear the lead journalist who covered this talking about the case fairly in a friendly way, actually, considering how adversarial they were. But I put them on notice that I would sue them if they kept treating my client unfairly. But they don't really mention the effect of the leak. But I think people need to know what's going on right now. And that's my reflections on what happened. I think, in closing, this is actually what happened. And I know by saying this, people are going to wet themselves behind the scene. They made a tactical decision, and I'm looking at you who did it. You made a tactical decision when you put the new junior prosecutor on. You said, we'll pull the more serious charge, the one that might have even been maybe easier to prove. We'll pull it so that the emails don't have to go in, which would embarrass the general. And then we'll go with the other charge, but then we'll try to get the emails in. And then hypothetically, a prosecutor could say, hey, if you don't want the emails in, just plead guilty to this other charge. And I bet you 100,000 that they thought he would flip and plead guilty because of the fear of those emails going out and the damage it could have done to their family. And the fact that we were able to prevent the emails from being entered into evidence made them realize that this strategy to force a guilty plea wasn't going to work. And they knew that once that strategy failed and I was about to launch and shed sunlight on what happened, they pulled the rug out of the case before General Whelan's story could be heard. And to me, that's prosecutorial misconduct. It's a negligent investigation and it's a malicious prosecution. And we will be hitting them with the biggest lawsuit they've seen in decades.